Thank you. I agree with Ms. Howard. This has been a long couple of days. I appreciate your attention to everything. You know, as Judge Brennan asked when we started yesterday morning, he said, why are we here? That was the question. Well, we're here for you to decide whether or not Ms. Hambly should be removed as public health officer based on her own words and actions and the charges that have been placed before you. Now, Attorney Howard claims that there's a requirement for a just cause standard. I would simply say, no, it's not. And she cites no law or anything to you that says that. What is required is what the board is considering right now, which is following the statutory standards under MCL 4611N. That's what's required. The words just cause are found nowhere in that statute. And we'll get into the charges in a minute and what they say. But 4611 says three things. A notice of hearing is required. It was done. Charges were presented to the board, very detailed and specific charges, over 20 pages and numerous exhibits of proof offered. Third, that Ms. Hambly has a full opportunity to be heard, and that has been done over the last couple of days. So how did Ms. Hambly use most of her 2 days of hearing time? I think that's instructive. Was it done? Did she use her time to present evidence to refute the specific charges? Did you ever even hear Attorney Howard say, charge 1, here's what it is, and here's why it's not true. Charge 2, here's why it's not true, and here's the evidence that we presented to do that. Have you even heard that? No, you have not. She spent the vast majority of her time attacking, smearing, and maligning others instead of addressing the actual charges against her. Now, it's very telling that the very first witness called by Ms. Hambly was Clerk Roebuck. Did he offer any testimony refuting the 4 charges against her? No, he did not. She attempts to use him in an attack on me for an offhand comment at a court hearing 7 months ago. As I clearly said at that hearing, I was not casting aspersions on Mr. Roebuck or anyone. I was simply pointing out the truthful fact that there was a board resolution that did not match the vote in the minutes at that December 13th meeting. I want to be clear here. And Ms. Howard, you can keep attacking me all you want, but I want Clerk Roebuck to know I have nothing but respect and admiration for your many years of service here. And I want to say it publicly. You have been an incredible servant to Ottawa County. Justin, I have no question in my mind as to your integrity, your honesty, and I honor your personal work and service that you've given the citizens of this county, and I thank you for it. But what we've seen here in the last couple of days is Ms. Hambly and her attorney's tactics of personal destruction on full display. Ms. Hambly called Mr. Waterman, Patrick Waterman, to the stand. An obviously disgruntled former employee who's upset because apparently Mr. Gibbs wouldn't talk to him enough. What does Ms. Hambly do through her surrogate? She attacks Ms. Dreisinga with smears and innuendo. Now think about that. What we're here for, and that's what they're taking their time doing. Mr. Waterman claims Ms. Dreisinga may have been doing personal or political work on behalf of some of the commissioners while on county time. And then he quickly admits, well, I don't have any evidence of that. You know, I can't prove it, but I just have to look at all the possibilities. You know, this would be like claiming, Commissioner Moss, you might be a drunk driver. I have no evidence of it, but hey, It's a possibility. I'm just saying. Or Commissioner Belknap. I've heard you might have falsified your resume. I'm not saying you did it. I don't really have any proof of that. But hey, I'm just doing my job. I'm just raising these issues. Those are ridiculous attacks. And Ms. Dreisinga did not deserve that. They're baseless. Those types of personal attacks are despicable. Hear me. And they do nothing to disprove the charges that have been brought against Ms. Hambly. Mr. Waterman then attacks us. Again, we seem to be a good target. Allegations about our competence, and there's people talking. Oh, wow. Isn't that something? The one specific claim that he does kind of bring up is that we failed to prepare a legal memo. Remember that testimony? We failed to do that. You know, I bring it up, not because to defend me or our firm. It's to show the misrepresentations and the deceit that is going on here. That they'll attack like that. You know, as Paul Harvey used to say, you need to hear the rest of the story. So was there a legal memo that didn't get done in a timely manner? Yes, the half-truth. So you want to know the rest of the story? That legal memo was requested in November of 2022, over 2 months before we ever took over as corporate counsel. The prior administration was asked to do it. And when we came in, nobody told me, Jack Jordan, Stephen Coleman, Lene, anybody, that there was this pending memo being requested. Nobody told us. Until 2 months later, we're told about it. We were going, oh, we didn't even know. Get us the information. What's your request? And we promptly researched it and we had an answer for them. But what were you told in this hearing? Look how incompetent Coleman Legal Group is. That's deceitful. It's misrepresentations, and that's the kind of tactics they're doing. Another example, we could talk about the epidemiologists. Okay. Again, you know, we hear all this. What's all this stuff about 2 epidemiologists versus 3? Remember the specific questions? And I bring this up to show misrepresentations, half-truths. What were the specific questions Attorney Howard asked of Karen when she was on the stand? What's about the specific line item? And that specific line item was the epidemiologist was cut out of that line item. But guess what? Ms. Hambly left it there. She didn't elicit the testimony from Karen that I did. I had to ask her. And remember what I asked her? Isn't there, in fact, a 3rd epidemiologist that was in another portion of the public health budget and it was fully funded? And she says yes. So again, the attempt to try to convince you folks that this epidemiologist issue had any merit at all, and it does not. This is a pattern, which is part of the reason why we're here. And I think it's fully spelled out in the detailed charges that are before you right now. And these are the charges that Ms. Hambly and Ms. Howard have shied away from for 2 days. Another example, Ms. Hambly continues to claim she was completely cut out of the budget process. Completely. Charges before you. Quote, she had no input into the budget process. The exhibits are all there. You can read them. Even in the face of all this contrary evidence that was presented to you on these charges and in these exhibits, in addition to that, you have the testimony of Nina Baranowski and Ms. Hambly's own emails that belie this claim of hers, that she was cut out. Ms. Howard just spent hours today with her own client, with Mr. Gibbs, going after email after email after email, showing her involvement while she claimed she wasn't. Look at Exhibit I. Is just one example. August 25th email. John Gibbs asked them to work with Nina and Chris Conrad on the budget. And you heard Nina. She's the liaison person embedded in the health department. They're on a daily basis. Chris works for Ms. Hambly as she's testified in the health department. All the emails, she was not cut out of the process. Yet she told the public that she was. Ms. Karazinski said she had multiple conversations with Ms. Hambly and lots of other people in this budget process. So that's one of the charges you guys have to decide. Now, I could go on and on with these kinds of misrepresentations, but I won't. I think you got a flavor of what you've heard for the last couple of days. And I think you've heard enough to see how this affected the public, and you're aware of that, and that those exhibits are in the record before you also. Now it's time for you to decide. MCL 4611 is clear. And I want to go through the three charges or the three standards that you can apply to the four charges. The first one is whether in the board's opinion alone, in your opinion alone, Ms. Hambly is incompetent based on the evidence before you to execute properly the duties of her office. If you find she is, she can be removed. And it's your sole opinion as the board. Secondly, whether on the charges and evidence that have been put before you in this hearing, in the board's opinion, again, that the board is satisfied that Officer Hambly is guilty of official misconduct and her misconduct is sufficient cause for her removal. Now, on page 2 of the charges, I invite you to use that when you're deliberating or looking at your decision here. We looked at these words, and there are no definitions in the statute. What does incompetence mean? What does misconduct mean? What does neglect of duty mean? And when there's nothing in the statute, courts tend to look at Black's Law Dictionary, other dictionaries, and get definitions. I want to read you, so you can see they're in there for all of them, but I want to read you the one for misconduct. The definition in Black's Law Dictionary: a dereliction of duty, unlawful, dishonest, or improper behavior, especially by someone in a position of authority. That's the standard, folks. Misconduct. And if you find, in your opinion, that the evidence before you meets that standard, then you can make the decision. The third one, whether on charges and evidence in the board's opinion, the board is satisfied that Officer Hambly is guilty of habitual or willful, doesn't have to be habitual, it's willful, neglect of duty, and that neglect of duty is sufficient cause for her removal. And again, it's based on your determination, your opinion, to your satisfaction. That's the standard. That's what the statute says. Under that one involving the duty, I just want to point out, you'll see in here, again, the definitions from Black's Law Dictionary says, for neglect of duty, a public officer's failure to perform one or more duties imposed by law. And so I simply want to point out that everything we've been talking about here, dealing with the budget and what Ms. Hambly was doing in August and September, was violating a duty imposed on her by law. And the specific law is MCL 333.2428, which is the law that empowers all local public health officers to run their divisions, run their departments. And also tied in with that is the exhibit that we admitted as either yesterday or today, with the job descriptions for Ms. Hambly, which says quite clearly under paragraph 2, she had the duty to be involved in preparing and doing the budget. And you've heard all the testimony regarding that. On all three of those things, if you find Ms. Hambly violated 1, 2, or all 3, she can be removed from office. Frankly, I think all 3 grounds are proven. I think the decision is clear. And I'll just end with this. I think it would be appropriate for the board to vote separately on each of these grounds, so it's clear. for the record. 3 separate votes, 1 vote on incompetence, yea or, your decision, yes or no. A second vote on misconduct, yes or no. A third vote, neglect of duty, yes or no. Those are the 3 grounds under the statute. And all you have to find is one of the 4 charges levied in these charges meet those standards under 1, 2, or 3, or all 3 of them. That's the decision you need to make. The decision's in your hands, and we appreciate your patience the last couple of days. Thank you.
Thank you, Mr. Coleman.